let's say I don't want to go to arbitration. I want to go to the court, but my contract mandates the dispute clause as arbitration. Is there any way around it?
Initially, no.
Well, I mean, it's a common practice. I mean, as Fernando said, sometimes you're going to get a better outcome through the court rather than arbitration because of the type of dispute that you've got, and sometimes because of the costs, which of course you will recover. Parties want to go to the court rather than arbitration. Now, what happens is if your contract mandates arbitration, you can always take a case to the courts anyway. However, the law says that if the other party points out to the judge on the first appearance that there is an arbitration clause in the contract, then the judge will say, sorry guys, you're right, I haven't got the jurisdiction, you have to go to arbitration within 8 days.
So is your only chance via naivety of the other party?
It could be, or it could be that the other party hasn't realized, or maybe the other party is interested in going to the courts as well, and they won't contest it. So you can try that approach. The other thing which is happening a lot, very often, and has sort of having mixed results, is that the law says that you can only go to arbitration, or you can only bind your company to arbitration if you've got the right powers of attorney. You've got the power of attorney to do so. So many times parties, and I'm sure you come across this many times, where either one party or the other says, hold on a minute, I know I signed arbitration in my contract, but actually, unfortunately, the guy that signed that didn't have the power to bind the company to arbitration. Therefore, Mr. Arbitrator, you don't have jurisdiction, and I want to go to the courts. So that is something which we see a lot. And as I say, it's having mixed results because the UAE is becoming more arbitration friendly, and they're tending to not allow that means of escape, if you like. And also the arbitrators are the ones that make the decision at the end of the day. And of course, if the arbitrators sit in there saying, do I have the jurisdiction or not to rule on this, he's going to have a tendency to actually rule, yes, I do have the power, because that means he goes ahead with the case and doesn't go to the courts.
It sounds like they're going to need to establish a case precedent, to fix the ruling on that. Otherwise, it will be different.
You can talk about that. I mean,
what I've seen so far, now that I've seen what the courts have been doing, is every time they see arbitration or the other party raise up to say there's an arbitration clause, boom, goes to arbitration. They don't want to hear anything more.
Okay, fine. So,
but some of the tactics I've seen, though, by some of the lawyers, especially the local lawyers who practice in the courts, is that sometimes they will try, if you're a subcontractor, you're trying to sue a contractor and there's a back-to-back provision in your contract, sometimes a way around the arbitration agreement, and you might convince a judge, it just depends how it's worded in the contract, to start the litigation with the contractor and also bring in the employer, and then base the jurisdiction on that back-to-back clause. I've seen that work before. And I've also seen it not work too. So maybe just say that.
So it sounds like, not everything is black and white. There is ways and means, and sometimes to take your best strategy or best approach, you need to talk to the right people.
I mean, one of the things here, in this jurisdiction, assuming it's the mainland Dubai, it's a civil court, a civil law system. And that means that there is no binding precedent like you get in a common law, so that's US or the UK. So that means you do get contradictory rulings, and the judges they look at precedent and it informs their opinion, but it's not binding. So it does lead to a little less clarity on some of these things.
And there's another thing that not many people talk about, and it's out there. And I'll be one happy to share. I tell my clients this all the time because it's I know it goes against my interests because I'm an arbitration lawyer. It's how I make my money. So a lot of contractors or just anyone actually who has a contract and it says arbitration in it. Let's say hypothetically it says DIAC on it, right? Dubai International Arbitration Center. They think, okay, I can't go to the courts. I got an arbitration clause, so we go to arbitration. But they're telling me, no, I need to get to the courts because I wouldn't want to spend all this money to go through the entire process. Something that there's some rulings in the courts where if, as maybe some of the people out there know, that when you start the arbitration, you have to pay the advance on costs, right? And the arbitration center is going to come off right off the bat and ask both parties to pay half of the share, right, of the total amount. And if one of the parties, let's say hypothetically the respondent, doesn't want to pay that share, which is a common practice in arbitration, and then the center comes back and says to the claimant, look, claimant, the other side's not paying their share, you have to pay the rest of that share. There's case law here, or cases, decisions, court says that if that's the case, the respondent doesn't want to pay, then that respondent has automatically waived the right to arbitration. And the case can be withdrawn, and then at that point, that contractor or company can go to the courts, and there will be no more arbitration.
Okay.